Montana has a reputation as a gun state, deservedly, and I would say proudly so. It is a Western tradition. Hunting is very popular, but more importantly, long distances between everything in this state make it especially true that you are your own first and last responder. And so by some metrics, we are the #1 gun state, actually, at least in percent of households having them, almost 2/3. In terms of guns per capita, this source rates us all the way down at number 16, but if you look at the methodology, those are just the guns that they know about. If you think the people are hard to find in Montana, well, the guns are hidden even better, and legally, we like it that way. We have constitutional carry in this state, and generally speaking, we have almost no restrictions on gun possession at the state level. Any non-criminal can buy and carry, no questions asked. There was one time the hippies in Missoula tried to mandate universal background checks for gun transfers within city limits, but per state law against such a thing, the Attorney General and the courts shut it down. So really, for gun law enforcement, it's just those pesky feds who sometimes bully us around here. Which brings us to this story, though in fairness, it may not be purely federal bullying. It may be, at least in part, a request for federal assistance gone wrong, but the headline in local Montana news is Billings man who displayed firearm across from school arrested, Billings being the largest city in the state. Displayed is an interesting term, implying this guy's sole purpose was some sort of show. Open carried is the appropriate term, as in he carried a gun in plain sight, as is legally fine in the state of Montana. And if you ask this man, 49-year-old Gabriel Metcalf, he says his reasons for open carrying have nothing to do with the school, actually. In recent weeks, Metcalf has been walking around his home across from Broadwater Elementary School in Billings, openly armed with a 20-gauge break-action shotgun. Metcalf says he does this because another man has been threatening him and his mother, and he wants to make sure the area is safe, in addition to exercising his Second Amendment rights generally.
I'm exercising my constitutional right to bear arms for self-defense and defense of my loved ones and others.
Throughout several days of this open carrying outside of his home and across the street from the school, parents and school staff called Billings police. And Billings police spoke with Metcalf and advised him that he was making others in the area feel uncomfortable, but since Metcalf had broken no Montana laws, he could not be arrested, and he was not. Until last Tuesday night, the 22nd, when the feds swooped in to make an example of him. Initially, the coverage I read made it sound like Billings police reached out to the feds to do what they could not, arrest this guy. If you read the affidavit that the feds have filed against him, though, they say that Metcalf actually reached out to the feds himself. According to the ATF task force officer on the case, Metcalf called the FBI to complain that Billings police were harassing him, requesting to speak with a federal officer. At that point, federal agents called him and, after that discussion, arrested him. But that's just one Fed's side of the story, perhaps inaccurate. I would like to believe that nobody would be so foolish, and I want to defend this guy as not kooky, and I will on principle, but if he actually did call the feds seeking the protection of his rights, well, maybe his critics are correct, actually. Maybe he is insane, because there's nothing crazier he could possibly do. Anyway, the feds arrested him and charged him, and now a federal judge is holding him in jail pending trial, warning that if he was released, there's no reason to think that Metcalf wouldn't do it again. Do what again, though? Because there is no allegation or documentation that Metcalf ever brandished his gun. He never pointed it. He never threatened anybody. He never harassed anybody, all of which are laws on the Montana books and charges that Montana law enforcement could not bring because he did not do them. Indeed, a neighbor witness interviewed at the scene described him as a friendly man.
It was just a little terrifying at first, but I think the second time that I passed by him, I actually waved at him and he waved back at me. So I was like, oh, he's not being hostile towards me, he's trying to look for somebody else.
A school parent speaking with a reporter appreciated that while Billings police couldn't get him, the feds now have.
I feel like he won't be able to just get out and simply continue on like he had previously, and the Billings police couldn't get him before.
As much as I can understand a parent's questions and concerns in this situation, We don't have a justice system of get him anytime someone does something that we don't like. We have a justice system of laws established through a process, and where none are broken, you can't arrest and jail a man just because you want him gotted. Unless, of course, the feds are deployed to get him, as they were in this case. But even the feds couldn't concoct a charge for violence or for threats. They had to think more creatively, and so instead they got him for simple possession. Possession of a gun in a school zone, a violation of the federal Gun-Free School Zone Act, which makes it a crime to possess a gun within 1,000 feet of a school. Metcalf never set foot on school property, or at least nobody is alleging that, and his actions actually had nothing to do with the school. He was within 1,000 feet of the school because he lives within 1,000 feet of the school. His home is across the street. So constitutional questions aside, which we'll get to, how is this law even supposed to work in practicality? If you can't possess a gun near a school, but you live near a school, are you just federally barred from ever owning a gun, even if you have a clean record? Technically, the law says you just can't possess the gun on non-private property within 1,000 feet of the school. But if the street and the sidewalk outside of your home are non-private places in which you can never possess a gun, as they're charging Metcalf in this case, how are you even supposed to transport a gun from your car into your home after you buy it? Or if you're a responsible citizen who carries a gun daily, how are you supposed to carry it if you can't leave your home to do it? Aside from that total void of practical sense, if you're asking yourself, how is this law even constitutional? You're right, because it almost certainly is not. The Second Amendment implications are obvious. If the feds can declare the sidewalk outside of your house as gun-free under penalty of felony, you absolutely do not enjoy your constitutional right to possess and carry a gun that the Supreme Court has established in the Heller and Bruin cases decided since this federal law was passed. But even beyond the second, how is this fact pattern federal jurisdiction at all? Because where there's a disturbance or a dispute within a state like this, that is within the state's police powers to handle per the 10th Amendment. The federal government has no delegated jurisdiction in this matter. So where are they claiming to get it? Well, even their claim to have it is invalid, actually, and not just by my opinion, but by the current legal standard. The first version of the Gun-Free School Zone Act was struck down as unconstitutional by the Supreme Court in 1995. The feds tried to say that the Commerce Clause gave them this authority, that since Article 1 gives Congress authority over interstate commerce, and guns generally travel interstate during manufacture and sale, they have the authority to tell you where you can and cannot carry one. The court did not buy that argument, saying that mere gun possession is not economic activity within the scope of the Commerce Clause, and so the law was overbroad and invalidated. Did the feds learn their lesson, though? No, of course not. Instead, they tried to worm their way out of it by adding some new technical language. Working with then Attorney General Janet Reno, Congress updated the law to say, okay, you can't carry within 1,000 feet of a school if the gun you're carrying has moved in or otherwise affected interstate commerce. So I guess if you made a gun out of materials sourced entirely within your state, well then it's F off feds. And I'm sure in that scenario they would finally abide. But of course, pretty much every gun has materials, parts, or manufacturing that happened across state lines. So this is just another way of saying the same thing with slightly more technical language, but indeed that technical language is very important to them. In the affidavit against Metcalf, the ATF officer specifically notes Metcalf's shotgun was in fact manufactured outside the state of Montana. Why? Because that supposedly gives the feds jurisdiction somehow. And presumably, because this law is so constitutionally dubious, federal prosecutors almost never bring charges on it. This coverage of the story over at AmmoLand notes that Gun-Free Zone Act prosecutions are extremely rare, and where charges have been filed, those defendants have generally been felons, which would make their gun possession illegal anyhow under other federal law. But notably, Metcalf is not a felon. Even if you think that he's strange, he has no criminal record, and he did not commit any crime in the common way that we think of the term, by victimizing somebody. He simply possessed a gun publicly in a way that Montana law says he's fully entitled to do, until the feds stretched to say, actually, that sidewalk is a federal no-no zone, even though that sidewalk is not federal property, it's city, and even though he can't access his own property without using it. So for the courts to consider, this case raises at least two crucial constitutional questions to consider. Number one, what sort of limitations can the feds place on the now Supreme Court established constitutional right to carry a gun in public, if any? And number two, what are the boundaries of the Commerce Clause? The Commerce Clause has long been a Fed play toy to stick their noses into anything and everything, because as long as something involved crossed state lines once, well, they have business now. And I'm not an expert historian, but the plain language of the clause reads to me like it governs economic interactions between the states, not an individual's behavior within a state, simply because he owns a product that once crossed state lines, which these days is effectively every product made and sold. Oh, you had a peanut butter and jelly sandwich for lunch today? Well, your lunch is now federal jurisdiction because that wheat came from Montana, those peanuts came from Georgia, and those grapes came from California. And so the feds will now determine whether you get creamy or chunky. And of course, we know that those terrorist bastards are picking chunky. And if that sounds like an absurdly broad application of the Commerce Clause, well, it is, but only for now, because it's the exact same reasoning that the feds are using with respect to guns. It's an interpretation that is well beyond the Commerce Clause's intent. So one would think that review from this Supreme Court would restrain it, particularly with reference to the court's decision in 1995 that already did that anyway. Plus, this court has already established itself as willing to affirm the rights protected by the Second Amendment too. So maybe this is a case that could get there and play its part in curtailing federal overreach, but of course, those appeals take years, and as far as his sentencing, years are what Metcalf is looking at. He will face a Montana jury, which certainly could work in his favor, but if he is convicted, Metcalf could get up to 5 years in prison, plus up to a $100,000 fine. He will endure years of damage before he ever gets the supposed redemption of a whoopsie and an apology from the feds, if he ever gets that at all. And all of this harsh treatment for victimizing nobody, not just in this instance over the last few weeks, but ever. This guy has never threatened anybody. He's never attacked anybody. He's never pointed his gun at anybody, let alone shot anybody. All he has done is possess a gun in a way that made others feel uncomfortable. And even if we sympathize with that and we think that their discomfort is valid, how to handle that legally is a question for the people of the state of Montana and every other state. Not for DC suits. Because if we deceive ourselves into thinking DC suits will solve our problems, number one, they won't. See every problem they're tasked with solving getting worse. But number two, they especially won't if that problem is irresponsible gun use. You may not like what this guy has done with his sidewalk patrol, sure, but if not, just wait until you hear about the federal patrol at the Idaho Mountain Home or the Texas Bible Camp, because the federal solution is often much more violent than the problem that your kooky neighbor creates. Thanks as always for listening and for supporting this channel always. Appreciate that thoughtful discussion down below and especially over on Minds. That is at ML Christiansen. You're always welcome to coming out and chat in my live streams. Those are linked down in the description. Looking forward to it. Goodbye.